Hi, I'm Dan Barker, co-president of the Freedom from Religion Foundation, here in the Stephen Yuill Friendly Atheist Studio in the national offices of FFRF. Today on Ask an Atheist, we're going to celebrate in the space of 8 days at the end of September and the beginning of October. FFRF has won 3 significant state church lawsuits. One dealing with a Christian cross on a Pennsylvania county seal, another case stopping Florida county from barring atheist invocations, and the case with the broadest consequences, winning our epic housing allowance lawsuit on October 6th against the IRS for giving the clergy a huge tax break. Next week, we'll discuss the Brevard County, Florida prayer victory. Today, we're going to talk about the Pennsylvania and the housing allowance victories. If you have any questions for us on Ask an Atheist, you can post them right here on Facebook, or you can send an email to askanatheist@ffrf.org. Annie Laurie Gaylor is in our studio. She's co-president with me of FFRF and co-plaintiff in the case which is called Gaylor versus Mnuchin, the lawsuit against the IRS that we just won last Friday. And also in studio is FFRF attorney Patrick Elliott, who handled the case that we won on September 28 in Lehigh County, Pennsylvania. So 3 victories within 8 days. Annie Laurie, that was pretty exciting. I was in Texas when you called to tell me about our housing allowance. You were running around the office. We won, we won, we won.
Yes, I was. I was jumping up and down, and I went through the whole office to tell people that we won, because this is a very hard-won victory. We first started taking this case in 2008, so this is our 3rd permutation.
Yeah.
And it's a complicated case. I thought that we could spend a lot of time talking about it after we first talked with Patrick Elliott about his very significant victory in Lehigh County, Pennsylvania. You were co-counsel, Patrick, in this case, and you want to talk about what it's about?
Right. Well, we, along with 4 county residents in Lehigh County, Pennsylvania, which is Allentown is the major city there, challenged the county seal, which since 1944 has had a large prominent cross in the middle. And so the county's representation of itself to everyone and to residents has always had this Christian symbol at the center of the seal. We, of course, as we typically do, requested that they, just via a letter, requested that they change the seal to something more inclusive. And the county commissioners voted against that, voted to retain the seal. And then we filed the lawsuit last year, under the Establishment Clause. And then just recently, the judge ruled in our favor and ruled that it was unconstitutional.
So the county was arguing that they could keep that Christian cross on the city seal because it was a part of the history. They were the original settlers in that county. So it wasn't religious, it was just a historical thing. And what did the judge say about that?
Right. Well, the judge looked at even that so-called historic rationale actually was religious. The person who put the cross on the seal said something to the effect that that the people of Lehigh County are God-fearing. So there wasn't even this. It was an excuse that I don't think it was based in fact, claiming that there was original Christian settlers in the county. And as you know, Dan, the Christians weren't the original people to settle in the county anyway.
That's right. On the day that decision came down, on the 28th, I was in Philadelphia for a big panel debate about the Establishment Clause and religious liberty. And Philadelphia is just the county in the county south of Lehigh County, so it was very close there. And I'm a member of an Indian tribe, the Delaware tribe, the Lenape Indians. And our tribe were the first settlers, not only in Philadelphia, but up there in Lehigh County. And so for the county to say the first settlers were these white Europeans with Bibles and guns who came over here is kind of a snub, isn't it?
Right. I don't think it was a rationale that was given, and I think it was, and we see this in a lot of our cases, and you've probably seen it for many years, once there's a challenge, the government will look for any excuse that they can find. So I think this just was a convenient excuse, not something that had been said for many, many years. It was something that they had to try to justify, why is this Christian symbol on the seal? And they came up with as typically happens, some historic rationale. Whether it's true or not, that's what we often see in these cases.
So Patrick, also, this is a fairly recent seal. I mean, this isn't a seal dating to the 1700s. When did they first adopt this seal?
Right. So this was adopted in 1944 and was designed by one of the county commissioners. And he gave an explanation for each of the elements and basically said, I think he described the cross as a huge canary yellow cross in the center. So it wasn't just one of a few symbols. I mean, it was definitely prominent.
Was the
it's
yellow?
in the center.
Was the yellow for some reason like holiness or something?
Well, crosses are usually gold.
It wasn't in the explanation. Now the counties use the seal in a few different formats, so it's not always the same canary yellow that they're using, but they've got a monotone version. But what's interesting here is they really use it on many things. I mean, it's on vehicles, it's on county buildings, it's on the county flag. So it's really, unlike some places, you may not know what the seal is here. And if you're in Lehigh County, you know what the county seal looks like.
Yeah, the legal responses that we filed showed that it's not just even on the seal itself, that the seal is on almost all the documents. It's the flags up at the airport, correct?
Right.
It's really prevalent.
It's going to be hard for them to change all that then.
Right. At this point, we're going to be briefing the court on, the scope of an injunction, as to how they have to address this. So it is something, as we've been saying all along, they should adopt an inclusive seal. And now they're, I think, going to be seeing the consequence of not doing that is they have to remove it from any number of places.
Well, it won't be that hard. They can just change out everything gradually, and they can get rid of the flag from the airport and put up a new one. That's pretty easy. Before we switch to the other lawsuit, I did want to say that we have also responded to this exclusion of non-Christians, this idea that Lehigh County is only for Christians, or somehow it only cares about the Christian settlers. And this is something that we see over and over again, this idea that Christians are first-class citizens and the rest of us be damned.
Right, and here I think what's interesting is, in reality, I think the county is more pluralistic than many parts of the country, at least according to some of our complainants or some of our plaintiffs have pointed out that there are a large number of non-religious people and non-Christians. And I believe Allentown is the third largest city in the state after, I think, Philadelphia and Pittsburgh. So, I mean, this is it's a major population center in terms of, the number of people that are there. Obviously, not everyone is Christian.
And that brings us to our all-important local plaintiffs. And we had 3 plaintiffs, correct?
We had 4.
4. And they're very brave and courageous, and we couldn't take these cases without people willing to come forward. So they deserve a lot of credit.
And Liz Cavell worked with you on this one too?
Right, we worked with my co-counsels, Liz Cavell, and then also Mark Schneider's an attorney out of Pittsburgh who we've worked on cases where in Pennsylvania where we've previously had victories with the 10 Commandments at public schools, and so Pennsylvania is a state that still has these religious symbols, and so we've been fortunate enough to work with attorneys there that are willing to challenge them.
Are they going to appeal?
We don't know yet. Actually, tonight is when their county commission is meeting, so we may know by the end of today whether they're appealing or what course they're taking.
And Liz Cavell was mentioned. Elizabeth Cavell is one of our staff attorneys. So we thank you all for your great work on that,
well, thank
Patrick.
you.
And so that brings us to our other significant win last Friday. Very late in the day, we got news that Judge Barbara Crabb here in District Court in Wisconsin had ruled once again in our favor. And she in our challenge of the housing allowance. And Dan, you're a former minister. Why don't you explain what this case is about?
Well, this is a fun lawsuit because we get to be the plaintiffs. We are named. In fact, the case is Gaylor versus Mnuchin. Mnuchin's the Treasury or the IRS.
Yeah, it didn't start off that way.
It started with Lou. It was Lou. And it was you and I, and it was your mother who started, who was a plaintiff when we began. And then after your mother died, her estate is still a plaintiff in the case. But in the IRS code, section 107.2, it says ministers of the gospel can exclude their housing from income. So when I was a preacher, You know, I didn't make that much money as a young preacher, but when I was a preacher, I was able to take a portion of my income that the church paid,
Your salary.
my salary, and not report that as income. So it lowered my tax liabilities. And so ministers of the gospel, which includes, ironically, rabbis and any other clergy who's
And
ordained.
also sometimes ordained basketball coaches and
Or, yeah,
cantors from
cantors.
synagogues.
They pay less taxes because of this exclusion, and that means the rest of us have to pay more taxes.
And I think we need to explain to anybody listening that this isn't just an exemption or deduction like a tax-deductible donation to a charity. This is actually, say your salary as a minister is $58,000 and $20,000 is given as a housing allowance. You only pay taxes on $38,000.
So it's an exclusion.
It's a huge benefit.
Yeah,
it's major. It's over $700 billion a year in money that $700 million a year that is not given back to the government.
Well, that the clergy are keeping, basically.
Yes.
They're keeping that $700 million for the ministry. Or I think the last one was $800 million. So.
$800 million. And you can also exclude things like curtains and swimming pools and you name it. And it applies equally to the very rich and the very poor. And we have been pursuing this since 2009, as I mentioned, and it started off in California, and then for legal reasons we moved it back to Madison, Wisconsin, with you and I as the primary plaintiffs, because FFRF has started to pay us through a housing allowance, which doesn't mean we get more money. It just means that they've set aside part of our salary as a housing allowance that we have not been able to get.
Which give us standing. Mm-hmm. That's the way we could say we are not clergy, but we are similarly situated. When I was working for a church that was promoting God, I got this break. But now that I work for FFRF, that's trying to keep religion and government separate, I no longer get that break. And so the government is picking sides, basically. The government's saying, you guys are the good ones, but you people, you atheists, you don't get this break. So,
and this is also from a 1954 law that was passed, and the purpose of the law was to reward ministers for fighting godlessness, which is not a secular purpose. I probably don't need to add. It's the opposite. It's an unconstitutional purpose.
And that the sponsor of the bill said that during the hearing when the bill was being introduced. It's to reward these ministers for fighting our common enemy, the godlessness. So.
And so this is the only class that's given this type of exclusion. There are other people who can claim that they should pay taxes on housing, for example, members of the military, or if you claim that you have a need for the convenience of your employer. But ministers as a class en masse are automatically given this exclusion, even regardless of where they live and what they use their house for. And Judge Barbara Crabb wrote a very careful decision, once again ruling in our favor, that this is a totally unconstitutional preference for religion, and that there are ways for Congress to come in and remedy it, but that they need to remedy it.
Do we have some of the wording from the decision we can look at?
Can you see that, Dan?
Well, I can read it.
Can you read it?
Yeah. Although defendants try to characterize Section 107.2 as an effort by Congress to treat ministers fairly and avoid religious entanglement, the plain language of the statute, its legislative history, and its operation and practice all demonstrate a preference for ministers over secular employees.
Yeah, and that's the whole nub of this case, is that there's a preference for one type of people in this country.
And do we have some more quotes from the case?
Well, she talked about Joel Osteen in the case, because there's a lot of these big mega church pastors who are not these poor little church mice. They're getting huge. He has a 10
or church mites.
Or church mites. They get, Joel Osteen, for example, lives in a $10.5 million, there's a picture of his mansion, and he gets to exclude that from income, the fair rental value of that property. He, and of course other big megachurch pastors, and many megachurches ordain a whole bunch of pastors.
Associate pastors
and music directors and youth directors, and in some cases are even ordaining their janitors and their basketball coaches. So they're all taking advantage of this big tax break.
And then, Dan, why would a church do that?
Well, it's financial. Churches want
Well, they do it because they don't have to pay ministers as much if the money is tax-free.
Yeah.
So it benefits not only the individual ministers, but it benefits the churches and the denominations.
Yeah, because they know that. They know that the salary they're giving to them goes a lot further.
And the rest of us pay much more because the clergy pay so much less.
Yeah.
Now, do we have another quote?
The final wording in the decision, I think, is pretty strong. Can you see that? The camera's blocking me, so I
Right.
can't.
Yeah. It says, under current law, that type of provision violates the Establishment Clause.
Yeah. So there we go. That's unconstitutional. The Establishment Clause is the first clause in the First Amendment in the Bill of Rights, and this IRS code violates that clause.
Now, I think that people don't want to get too much into the weeds here, but we should probably explain the reason that this is the second decision by Judge Crabb.
Yeah, so we sued and we won in 2013, was it? And the judge said that it's undeniable that you and I are not ministers of the gospel, or that our salary is not being paid by a church. But the U.S. government, under the Obama administration, they appealed that loss to the Seventh Circuit. And the Seventh Circuit back then did not say we were wrong on the merits. They simply overturned us on standing, saying, and this was funny because in their brief they said that you, Annie Laurie, don't actually know that the IRS would not consider you to be a minister of the gospel too, right?
Slightly ridiculous.
It is ridiculous. You're a third
They
generation
were trying
atheist.
to making any argument they could to say that we didn't have the right to sue.
So how do we know that we're injured if we didn't try? So they booted us out. We lost the case on standing. So then we had to go back, and it took, what, 3 years or 2.5 years of asking for amended returns. We submitted amended 1040X to ask for a refund.
I think that maybe we didn't quite make clear to somebody who doesn't know anything about this case that the reason they said we lost on standing was because you and I did not actually ask for the refund from the IRS. Do you remember?
Yeah. And so
Judge Crabb said it would be ridiculous to make us go through those motions because they're obviously not going to give us the refund. But the Seventh Circuit basically gave us a set of instructions to follow on how to get back into court and get standing.
So
and
we
we followed those instructions.
We went through the motions, and in one of the returns that we asked for a refund, we got a very strongly worded refusal from the IRS saying, you can't do this. This is a legislative thing. We don't have the power to give you the money back. So that wording is quoted in Judge Crabb's decision showing, see, look, now they really have been harmed. They asked for it. The clergy get it, but they didn't. So we're back in court, and that's why we won a second time. And if it's appealed, I assume it will be, then the court's going to have to wrestle with the merits of the case this time.
Well, if they are honest, they're going to have to wrestle with the merits. And I should also say that the good old Beckett Fund is intervening in our lawsuit, and they immediately said, oh, we're going to appeal. But of course, the government is the main actor in this. And also, Judge Crabb has asked for additional briefing. Do you want to explain that, Patrick?
Right. Well, the judge asked for additional briefing. You know, she had ruled that that Section 107.2 is unconstitutional, but then also asked if additional relief is warranted as to the remedy, because as a court, they can issue injunctions, can also potentially could extend the benefit to others. The judge seemed concerned about that because that's a task for Congress. That's a task for the legislature to decide who gets this type of tax benefit. So that's something that is, I think, goes through maybe close to the end of October before the parties could potentially brief that.
And we haven't really discussed that yet, but do you want to talk about some of the remedies that she proposed?
Well, I don't know if any of them are seriously discussed. As part of our brief, we pointed out that it is within the power of courts to extend the benefit if somebody's being discriminatorily excluded. And so potentially that there would have to be a ruling that secular employers would also be able to provide a housing allowance if it's designated by the employer. It seems that the judge is concerned about that because, again, this is something that Congress would decide how that impacts revenue and as a policy matter. However, it is something that courts have done in other cases, and so it's something, obviously, that you and Dan and us would be speaking with our litigation counsel and decide.
Yeah, we're working with Rich Bolton here in Madison, and he's actually taken all 3 of our cases. He's could write these briefs in his sleep now. Yeah, I think also she said there's many ways that Congress could address it. They could overturn it. They could start saying there has to be, it has to apply equally to all secular charities and religious charities. Even that they could put financial limitations on it. And she said there's a number of ways that it could be made constitutional, but what they are doing now is not constitutional.
But then we would ordain you, Patrick, as not a minister of the gospel, but as whatever they call it if they change it.
Patrick's already getting part of his allowance designated officially as a housing allowance in preparation for what may happen in the future.
And all of our attorneys could then get the same housing allowance.
All of our attorneys are being paid through housing allowance.
But think what would happen across the country. Every nonprofit then would start saying, we're all going to start grabbing this thing. Instead of 700 million, it might be 700 billion.
Yeah, and then what's going to happen to our infrastructure and the governmental ability to function? But they can't give a benefit solely to ministers that they deny to other people who are in the same status.
Okay, but legally, since that code has been declared unconstitutional, isn't it technically nullified? I mean, isn't it technically zeroed out, and Congress is going to have to replace it, or they can't just tinker with it, right? They have to replace it.
Right. Well, right at this point, that's the ruling. Of course, the other side we're expecting may well appeal, so it may not go. It may not go into effect. I think Judge Crabb also asked about staying any of this type of relief, with the idea that probably the other side would appeal. You're right. If it is nullified, then ministers can't claim this exemption, or Congress is going to have to create some new version of it or adopted a whole new scheme. And I think what I thought most interesting in part of Judge Crabb's opinion is she mentioned, in addition to the rationale being to fight the godlessness, the idea was we have to pay our ministers more. It's such a good thing to pay our poor ministers. And I think Judge Crabb indicated at some point, but what about all the other people who are poor?
School teachers, for example. School teachers are doing a great moral service, and that most of them are underpaid.
Well, all kinds of people don't earn very much money.
Yeah.
This is not an argument, but when we won in 2013, I got a call from almost tearful wife of a pastor, that's how she identified herself, complaining to me how much her husband needed this write-off or this exemption. And I said to her, but just because he's a minister, can't you see that that's unfair? There's people who work at McDonald's are earning a lot less, and they don't get to get some kind of housing allowance. So, the whole idea is clergy privilege, religious privilege. It's a given in our country. And when we won this last time, and it was appealed to the Seventh Circuit, almost every church denomination in the country signed, they call them friends with the court briefs, they were not friendly to FFRF, saying how awful this would be. Even the Unitarians, which disappointed me a great deal, because Dan and Patrick, I think we all know, once you have a tax benefit, nobody wants to give it up, and they're going to fight like hell to keep it. But then they have that extra religious bias that somehow they deserve something the rest of us don't. They're above the law.
They're a higher class of people in a country where we
because
the
they're
people
religious.
Are all, and that goes back to the state church entanglement thing of Europe, where there were the people, and then there was the clergy, and then there were the kings. So there was a higher level of people. And in our country, there isn't. In our country, we call our president Mr. President. There's no higher level. We're all supposed to be treated the same.
Well, I agree. And then I think that the only other interesting aspect of this is how the whole case began. And we can tell you the inside scoop, which is that in the early 2000s, Rick Warren, do you remember? Yeah,
the purpose-driven life, the big megachurch pastor that did the opening prayer at Obama's first inauguration, that big.
And he was living in a mansion, and guess what? On his tax form, he was taking more than the fair rental value of his mansion when he was paying his taxes.
Well, for 1 year, the church designated his entire salary was a housing allowance, and he paid zero taxes.
You can see how unfair this is. I mean, people should be sort of up in arms over it. Well, the IRS was up in arms over it. They sued him.
No, they didn't. They
Well,
made a determination.
They made a determination, and
then
he sued
them.
And then it moved from tax court into federal court, and it was before the Ninth Circuit Court of Appeals, which is in the Northwest, and they asked a very famous law professor, Erwin Chemerinsky, to brief the court. And Erwin Chemerinsky wrote a fabulous brief. You can Google it and find it online, saying that this is unconstitutional. You got to get rid of it. And this was open to the public to read. And the churches and pastors all got panicked that the Ninth Circuit was going to overturn the housing allowance. And almost overnight, they changed the law.
Congress
stepped in overnight just to save the skin of Reverend Rick Warren. And they said that they're going to amend the housing allowance so you couldn't declare more than the fair rental value of your house, or in his case, mansion. And they made it retroactive so that Reverend Rick Warren would not have to owe any back taxes. Now that's the power of the clergy over Congress.
But he's still getting, if he's still getting the full benefit on a multi-million-dollar home. It's just whatever the typical mortgage and carrying costs would be for that home. So
that's
it's still
right. They didn't overturn it at all. But they took steps so that it wouldn't be quite as vulnerable, and to save him from having to pay back taxes. And so last time we won, and there was a huge uproar by all the churches. And we would expect this. It's kind of slowly filtering out. But last weekend, I think it was Christianity Today, posted a story where they very affirmatively and confidently said, well, no matter what happens, this would only apply to the Seventh Circuit, to the Wisconsin, Indiana, and Illinois.
But that's not true, is it? It's a federal decision, right?
Federal courts can strike down federal laws that are unconstitutional, so it would have national effect. Whether how the IRS actually treats it is something to be determined.
And depending on the ruling of the judge. I mean, she was holding off pending the briefing, but this idea that somehow only ministers in certain states would have to pay their fair share and the rest of them could get away with it. I mean, they're sort of desperate.
I would think this is a great opportunity for the church. The church can say, we don't need a tax break. Our God is powerful enough and rich enough to pay our clergy what they deserve to make a living wage. Wouldn't this be a great chance for them to say, forget it. We don't need to go begging from the taxpayers. We've got an all-powerful God. And yet what are they doing? They're groveling.
Well, and also indignant that they deserve this break that nobody else gets. And Judge Crabb also it was a very smart ruling, very thorough, where she pointed out that ministers can make this claim that they have to be at a particular house, they had to buy a house in a particular neighborhood for the benefit of their church. But then they have to make their case individually to the IRS.
Just like anyone else
Just
would.
like anybody else can make that case. That law exists. The IRS doesn't have to agree, but right now it's an automatic exclusion.
Like if FFRF required you to live in this building here where you have to live here, well, then you could make your case. It's for the convenience of the employer, whether you're religious or not.
Right, and that often is applying to more so the in-kind housing. I mean, that's the most typical situation, rather than the direct cash payments that's just excluded from income.
Yeah.
So even on that basis, there may be pastors that would qualify, but it certainly wouldn't apply to all pastors who are just getting paid and don't want to pay their fair share of taxes.
Like if there's a few doctors in the country that actually are required to live in or at the hospital, does that mean, well, now all the doctors in the country now get that because there's a few that need that, right? So that's kind of what was happening with this IRS code.
And there's one other thing that we haven't talked about, which is kind of how this came about in '54, was that the Protestant denominations and ministers were jealous about the Catholic.
Most of them, yeah.
Because so many priests and nuns, they have housing provided for them.
Parsonage.
Parsonage, and so there's a parsonage exemption, which is separate from the housing allowance. So this was Congress capitulating to the Protestants, who are a majority, to say, oh, we should give them something too. But again, that's a different situation. It's more equivalent to the military, someone having to live on a military base.
I mean, it seems that the basis behind it too is if the church owns that housing and somebody's living there on a temporary basis, when they cease living there, they haven't they don't own that home. Yeah. Whereas a pastor at a Protestant church that's getting paid $30,000 a year in a housing allowance is purchasing a home that they are getting a financial benefit. So it makes
they own
complete
it. They
sense.
have the equity. They can sell it and do whatever they want with it.
So before we go to questions, there's a rabbi here in Madison, Wisconsin, who refused to live in they call it a rabbinage, the parsonage that the synagogue provides for them, because he wanted to own his house so that when he moves, he would gain the appreciation of the sales of the home. He didn't want to live and he wanted that housing allowance then to help pay for his housing expenses.
A good deal if you can get it, but it's not constitutional and it's not fair.
So, questions? Do we have questions?
Yeah, let me see. We've got a few questions. Mark says, "Hey atheists, why go after a city's history? Doesn't Lehigh County have the right to acknowledge its own history?" I mean, I guess the first response, and I guess I alluded to this before, is these historical claims often aren't true. We're seeing that in these cases where I think we're even seeing that in some of our cases against crosses on public property, and they say, oh, this was somehow like the Mount Soledad cross. Oh, this is a war memorial, and there's really no history of it being a war memorial until after the fact. And so here, this was always viewed as just a Christian cross, and later on, the county tried to come up with a justification that it was to honor, early Christian settlers, which even if were true, would still be a violation of the Establishment Clause to honor the early Christian settlers, which I think the judge actually alludes to in the opinion. But I think when I think of the historic claims, I think one, that's often the excuse that some government will come up with for violating the Establishment Clause, and two, it should be fact-checked, because oftentimes, like here, it's not based in reality. It's actually just an excuse.
But also, a majority of the European white settlers were Christian in this country. So that would be like saying we're a Christian country. It's the Christian nation myth that somehow the individual preferences of Americans becomes the governmental religion, and we do not have, the United States does not have a religion. We have a secular, godless constitution, and it doesn't matter what your religion is. You're all equal under the law. But by that argument and by that token, you could say crosses have to be on everything.
I know what they should do. They should replace that cross with a turtle shell, because my clan is the Turtle Clan of the Delaware Indians, and we were there first. So all they would have to do is take the cross and kind of round off the edges of it, and that would look like a turtle shell.
Well, Dan, that would actually be a secular and appropriate thing to do, though.
Yeah, because it's not religious.
No, that would be truly honoring the history.
And there's no separation of turtles and state in our Constitution, right?
All right, we have a question on the housing allowance. What if pastors are poor and need the tax break? What if the government gave the tax break to people of a certain income level? And what's the reaction of the churches? I mean, I think these are, I guess, three separate questions. But, the first question, what if pastors are poor and need the tax break?
Well, and I think we did answer that, and that question probably came in as we were talking. Many people are poor. Many people are very poor and more needy than most ministers, and yet they don't get the housing allowance. And how could, our tax structure hold if that's what we're going to do?
But poor people do get a tax break under our graduated system right now. There's tax brackets, so if you're a poor person, you're already getting...
If you have a lower income,
you're already getting some kind of a break.
You can argue that it's still not very fair compared to corporate taxes, but that is not how it is structured. And I think the second question alludes to that.
Yeah, what if government gave a tax break to people of certain income level?
And so they do, as Dan said, but this law is not based on income, and it still would not be constitutional if it singled out ministers of the gospel, as the law says, for a tax break if they are poor. Judge Crabb addressed that. There would have to be something that had a secular purpose that applied equally to anyone, regardless of whether they were a minister or not. So similarly situated people.
Maybe theoretically, if the government said, we're going to extend this exclusion to all nonprofit leaders who are under a certain level of income, that might have that might withstand the challenge, right? Because it's not separating out clergy for special case. So I think that's what that question is asking.
But it might not be good for the country
No,
to do that.
but it might work. You know, it wouldn't be great, but.
And then, so I mean, I guess you alluded to this a little bit, but what's the reaction of the churches?
Well, you know, as I said, they're starting to minimize the decision. They're trying to say it only applies in Wisconsin or it only applies in the Seventh Circuit. And I think they're in denial. I think that they will be amassing their amicus briefs and being indignant. But the news is just percolating down. It came down very late on Friday, and Associated Press didn't get a story out until Monday afternoon. So it's just starting to be known by churches. So we haven't seen the whole reaction yet, but it's going to build.
Well, I read Tony Perkins of the American Family Association is outraged by, he's going after the judge, right? He says, here's this liberal judge making another, she's the same judge who ruled against the National Day of Prayer, and this is, you know, this is just all a blowback of the anti-religious Obama administration, is what he said. But of course, it was the Obama government who appealed our victory back in 2013. The Obama government wanted to keep this for the clergy.
Right. Okay, Lisa Marsh says, congratulations on so many victories. It's been a lot recently. Do you think any of the recent decisions are going to be appealed and or overturned?
Well, we don't have a crystal ball.
Wait, I have the gift of prophecy. Wait, let me look and see.
So look at it's your decision. I guess we already talked about it. Do we have any scuttlebutt yet in the county? We're hoping they don't appeal.
In Lehigh County, we don't know yet. You know, I think when you read, sometimes you can read a judge's decision and have an idea. The case law is so well settled, they have very little chance of winning an appeal, of any type of appeal. In the Lehigh County case, the judge, I would say, reluctantly ruled in our favor and didn't seem to want to apply the Establishment Clause in this way, but was bound by precedent. And
so the judge was sending a signal to the county, hey, maybe you should appeal.
I don't know that that's the case, because in order to actually win an appeal, you know, a full en banc panel of the Third Circuit Court of Appeals would have to overturn a prior panel decision. Right now, all of the decisions in the Third Circuit say, hey, the Establishment Clause applies to government entities, and we apply the Lemon test, and this is, you know, and this is how we apply the test to religious displays. So it would really take very extraordinary circumstances in order to overturn the prior decision by the Third Circuit, which is either a full Third Circuit decision or a U.S. Supreme Court decision.
But I think this is the second case we've won this year at the district level, the first level, where a judge has made a similar kind of mean-spirited, disgruntled remarks, even on page 2 of this decision in Lehigh County, saying, I don't like the precedent, but I'm bound by it, so I have to rule in favor of the Freedom from Religion Foundation. But I think that it's wrong. In other words, they want to overturn precedent, the Lemon test. This happened in the Pensacola case that we won, which they are appealing in Florida over a giant cross in a park. And so, of course, I think they're looking at the political wins. They're looking at the Trump administration. They're hoping that there's going to be a change on the Supreme Court. And they are really going after years and years of very important state church establishment law, protecting the separation of church and state. So I think this is very concerning when we see federal district judges begrudging the First Amendment.
But he did say the law is the law, and he did the right thing. Even though it was reluctant, he did the right thing.
But of course, if I was a county board member reading that decision, I would think, oh, maybe we should appeal and waste taxpayer money.
Right. Yeah, I don't know.
So in terms of this case that we've been talking about, the housing allowance, I would be quite certain that they're going to appeal. I would think there's not a chance they won't appeal. This is bound back for the Seventh Circuit because they're the ones who said we had no standing, and now we've done what they said. Now they got to look at the merits. And then the other case, well, we'll talk about that next week, Brevard County. We are hoping that won't be appealed. That's the atheist invocation case. So, you know, a lot of this is based on firm precedent. The thing that makes our challenge rather historic, Dan, is that this is really a different sort of challenge. This is something that's never been done before. There isn't a case law on the housing allowance.
Yeah.
We are looking at established principles, of course, and we're right. But it's not like we can cite a case as we could in Lehigh County saying you can't put Christian crosses up in parks and on county seals.
I got to tell you, though, if you're ever thinking about suing the IRS, be sure that you have been scrupulous with your own taxes. Because remember when we spent those 2 days under deposition, the U.S. attorney came into Madison and we had to go through pages and line by line of all of our past tax form. And if they had found anything to knock us out, you were there, weren't you?
Yeah, I
yeah, I think
remember.
you-
Well, I mean, as many people probably know, Dan plays music, and so I think there were some questions related to compensation you had received that you declared on your taxes for some of the gigs that you've played, and so it was a little nerve-wracking. I'm sure nobody would want to be in that
But
position.
there was no problem, but still your whole life, the government has all these resources. And then it was so funny when she was done, she closed this big red binder on me, and then kind of like Columbo, she turned around and she said, "Oh, by the way, were you ever arrested for drunk driving in the state of Missouri?" And I said, "What? What? Some other Dan Barker schmuck must have got arrested and they thought they got me, or because I had testified, I'd never been arrested or convicted or any of that. So I said, that wasn't me. I've never been drunk in my life. So, but that shows you the extent that the government could go to with all the resources to try to knock you down.
Right. I mean, I think you're pointing out too. Annie Laurie thanked our plaintiffs in our other case, and I guess I thank you both because it is a burden sometimes to be a plaintiff. Being under oath and having your deposition taken by a lawyer who presumably is trying to ask you questions to make you be uncomfortable is not a pleasant experience. So we're always legitimately grateful to our plaintiffs, and we've seen what they have to go through just to enforce the First Amendment. So thank you for that.
Speaking of
No more questions?
Speaking of the plaintiff, the estate of Ann Gaylor, Ann Nicole Gaylor, who's the principal founder of FFRF, she's my mother. We co-founded FFRF together, and she was very interested in this case. Died 2.5 years ago at 88, at a point where she had asked for a refund. They had denied it. She had filed the proper.
Did they deny or just not reply?
They didn't. No, they sent a weird reply, and they didn't give it to her. And then she asked for it again, and then there was no response. But because you have to wait at least 6 months. We actually waited a year. In the meantime, she had died. So my twin brother, Ian Gaylor, who is a life member, is also serving as plaintiff, and so we want to thank Ian, representing the estate of Ann Gaylor. So the estate of Ann Gaylor still has an interest because we had designated some of her retirement as a housing allowance. She just wasn't able to get the refund. So thanks, Mom and Ian.
All right, I don't know what we have on time, but somebody just asked, how can a law student graduating in 2018 get involved? I mean, I think if this person's going to be licensed to any bar, they can always reach out to FFRF. We work with attorneys in a number of states. They can participate in, local events of other civil liberties groups if it's the ACLU. But I think there's finally being a little bit of a pushback on our side of enforcing the Constitution and protecting the First Amendment. So I would encourage any attorneys interested or recent law students, to get involved.
Yeah, and also to contact FFRF once they have passed the bar, they're up and running, to let our legal director, Rebecca Markert, know that they're interested in working with us, because we often have trouble filing cases around the country where we don't have a local counsel. It makes it so much easier to have somebody on the ground there, even if they're not arguing most of the case. Whoever that sent that, I would say, please be in touch with us, and Rebecca Markert keeps careful track. We also have members who want to work with sympathetic attorneys sometimes. They want to draw up a will, or they just have encountered prejudice and they want to deal with somebody who doesn't care that they're an atheist. So sometimes we have resources like that we keep on hold.
So I think that was our last question. Well, thanks for watching Ask an Atheist this week. I'm here with Annie Laurie Gaylor and Patrick Elliott with the Freedom from Religion Foundation. Next week we have another show like this. We're going to talk about our victory in Brevard County. We'll talk with FFRF attorney Rebecca Markert about that victory. So
and PJ Slinger will join our editor.
PJ Slinger's going to join.
Yeah, he's going to talk about our Nothing Fails Like Prayer contest, which has become, I think, of much more importance with this decision about atheist invocations. You know, how you can get a expense-paid trip to FFRF's National Convention next year if you give an atheist invocation.
The convention
before your
in
San Francisco.
San Francisco.
November 2nd and 4th. If you give an atheist invocation before your county board when they allow religious prayer. So he'll be joining too for the first time. So that'll be fun.
Well, thank you for watching Ask an Atheist.